Hi, my name is Gurkirat. I'm an employment lawyer with Kent Employment Law in British Columbia, Canada. I get asked a number of questions in my role as an employment lawyer. One of the most common questions that I'm asked is by both employers and employees, do we need an employment agreement? There's no law on the point. It's not a legal requirement for you to have a written employment agreement. But then you would definitely want to have one just so that the respective rights and responsibilities of both the employee and the employer are clearly laid out. You don't want to be getting into a dispute at a later date as to what your rights and responsibilities are. Therefore, it's always best to have a written employment agreement in place. If at all a dispute did arise and there was an oral employment agreement in place, the evidentiary burden of proving an oral employment agreement would be far higher than the evidentiary burden of proving a written employment agreement in court. So therefore, it's always best to have a written employment agreement in place. That's an interesting question because it has an equally interesting answer. The employment agreement should always be signed before the day the employee comes to work. If it is signed on the day that the employee comes to work, like if the employee started working and you made him sign the employment agreement at about 1 in the day, well, in that case, the employment agreement will likely be unenforceable. Therefore, it's always best to have the employment agreement signed at least a day prior. The other variation is that at times employers want to put in place employment agreements with respect to employees who are already working for them. Now, it's not as simple as that, handing over an employment agreement to an employee who's already working with you. You need to offer that employee over and above what he's already getting. That is, that's called consideration in law, and you have to offer him something over and above he's already getting, even if it's $1 extra. Ideally, no employee would agree to sign an agreement if you just offered him $1. So you should offer him something which has a value in the eyes of that employee. There is again no law on the point in the sense that the government does not mandate that a certain specific time period should be given to an employee to review an employment agreement, but it's always best for the employer to give reasonable time to the employee. Now, what is reasonable will depend upon the facts and circumstances of each case, but I would say that it should at least be a period of 4 to 5 days. That takes into account all sorts of situations where you have an employee who has the means to hire a lawyer as against an employee who does not have the means to hire a lawyer to review the employment agreement. Therefore, it's always best, as I said, give the employee that time period, and that should be good. If you have further questions, I would be happy to address them. You can always reach out to us at Kent Employment Law, and you can always look up our website online.